Good morning, Judge Bush's chambers. My name is Chris Sebastian, and I was told that I should try calling back in a week, so I'm calling back in a week. I have,
Yes, sir. Can you hold one moment, please?
Okay, do you need my case number or anything?
No. Hold on one moment.
Great. Nice music.
Yes, sir.
Yes, ma'am. I'm sorry. Your name is?
Victoria?
Hi, Victoria. Okay, we've spoken before then.
Yes, sir. How are you?
I'm well, thank you. Always a little stressed while these matters have not been settled adequately, and very unhappy about such, but trying to do my best to show everybody that I'm working on all fronts to meet the court's requirements and to protect my due process rights at the same time.
Yes, sir.
In any case, you said that, or I spoke with another lady after I'd spoken with you.
Yes, hello.
I said that, this was again last week, and I said that I needed to get this psychiatrist competency contract finalized because it incorporates best practices and meets all of the court's requirements and meets my protective due process requirements too. I ended up a couple of days ago getting an email from a Counselor Sims, who is kind of like the family's lawyer, not my lawyer, but the family's lawyer. And he suggested that all I needed was a 2-page contract, but already that was a new suggestion, if you will, because I'd been told beforehand there was to be a psychiatrist provided, but I had no say in any contract. It still was supposed to be my psychiatrist, so I'm supposed to be able to contract and have a say, especially when the terms are such that they're protective and I need to see them before I see anybody. Anyway, the lady kindly said that I should and could send the court the final draft that I've got so far, and that it would be reviewed, everything would be reviewed. Now, at the same time, I have found all of the questions that all of the major research, in terms of doctoring types, research, people have come up with regard to what kind of questions one asks somebody who might not be competent to stand trial. And I have several pages worth of questions, some from states, what the states mandate, like the state of Florida and so on, and they're all very similar, and I've answered a bunch of them. Already the judge has in her file, again, a rough draft of those questions, but I have them much more comprehensively organized now and separate from everything else, so, it's not a mixed bag that the judge might be getting. I would like to send that to the judge, because I've answered half the questions, and it again shows competency, and it shows an effort on my part to find the rules of law and meet the court requirements in terms of meeting the objectives and nature of court mandates, as well as meeting my objectives in terms of due process rights. So I've got the contract, and I've got these questions that I would like to send the judge, and the emails with Stuart Sims. because he said I could have a 2-page contract, and I said, well, send me the contract, and then I can upgrade it with the clauses that I need in there that meet my protections, if you will. And I've heard nothing back from him. And this has kind of been a pattern. Every time I've gone to court, at the last minute, people have said, well, you can meet this person, but nobody's wanted to contract appropriately. And then they send me a letter saying, well, we offered to let you meet this person. And then nothing. I don't hear from anybody until just before the court date. And there we are with nothing having been solidified and performed on in terms of, contract and then performance on that contract. But you can't perform until you've contracted. And I want to ideally keep the judge up to date with my efforts, because I'm showing good faith performance efforts, and I'm asking people to advise and assist who are there and supposed to advise and assist, but who have not. And if my due process rights are being breached, that really puts a crimp on any prosecution and so on. For instance, the motions to suppress that I've been asking to have authenticated, nobody wanted to produce on discovery. The judge hasn't acknowledged having received, and Hunter said was hearsay, as though I've got on tape that Sims told him it was real. Now the prosecutor has that poster with those documents in there. So the discovery that they didn't want to discover, that the psychologist has said is dubious, though they're public documents with other people's signatures on them, and the law, Rule 902, says that they're already authenticated, now the prosecutor has. That might be grounds for the prosecution to decide to drop the charges, as well as for the judge to decide to dismiss the charges under Rule 37 of the Federal Rules of Evidence. When people refuse to cooperate with discovery, that puts a crimp in due process rights to controvert. So here I am with all these things up in the air, and if I were to ask for the prosecutor to return my poster because it's tangible property, then everybody sees what they got. And this is the very stuff that they tried to give to the psychologist so that the psychologist could poo-poo it so that nobody had to be accountable or responsible in terms of public documents authenticated that show net worth evidence and show impeachment evidence and exculpatory evidence, which I'm supposed to be allowed to introduce into court. And indeed, by law, I'm required to with regard to the net worth evidence in any case, because the law requires in pretrial hearings that you have the CJA investigators investigate your net worth, and it's perjury if you're not giving people the right information. So I'm giving them information on net worth stuff, inclusive of government having grabbed net worth stuff, as well as grabbed me, which, according to Sims in his motion to suppress evidence, I was grabbed illegally, but nobody's remedied that. That was for 2.5 years. That's got to deal with net worth. And nobody wants to look at that because they don't want to look at prior bad acts, is what you call it in law. Anyway, here I am, and I kind of like to know if the judge has made a finding on the motion to stay or dismiss.
No, not yet. She hasn't ruled on it yet.
Okay. Well, I've taped this conversation, and I think I've tried to explain in the conversation in a holistic way where the various points and my analysis of what I need to do and what I am requesting the court to do and what the hurdles seem to be. Do you think that I should send the judge a copy of this tape so that she can, at least see where I'm coming from?
I can't advise you, sir.
But you can relay this all information you've absorbed it all?
Yes, sir. Yes, sir, I will. I definitely will.
All right. Well, I will go ahead and I'll tell you what I will do is I will send this information on Monday, because that gives me a chance to make sure it's as pristine as I can get it, considering I'm not a lawyer, but I've got a good reasoning mind. I'm lousy in spelling, but I've got a good vocabulary. Anyway, I will try and I will get it to the judge on Monday. And at the end of every week, I will send her information to show her that I'm trying. I'm really, I'm trying. But if people have misbehaved beforehand in government, and I'm little and they're big, it's difficult to, force people to do stuff when they don't want to face the repercussions of what they've done already. And it all has bearing in this misdemeanor trial. Very real bearing, at least for me, and has from way before this misdemeanor trial began. It's been a problem for me for the last decade, trying to get people to acknowledge and authenticate and adjudicate property and rights. I have been damaged in those rights. Anyway, my dear Victoria, thank you so much for your ear and for allowing me to do my best to be in communication with the court and show that I'm trying to do the best I can.
Yes, sir. Well, you have a good day.
I thank you, ma'am. And again, I've recorded this, and so you have the information, and I've tried, and if you want a record of it at any point in time, you should let me know.
Thank you.
I'd say who thanks you.
Bye-bye.
Have a good day.